Hi, and welcome to the Florida Family Law Attorney Podcast. It's been a while. We've been took a little break from for Christmas and the holidays, and we're back at it for 2026. And I'm very excited about this guest. It's a gentleman I've known since I started practicing law here in Bay County, and I've seen go a long way with his career and helping countless people in our area. Today's topic is going to be one that I think is kind of fascinating. It's a night where everything changes. The DUI arrest, being pulled over, the whole experience going to jail. And that happens quite frequently, unfortunately, to a lot of people. And it has life altering events, not only in the criminal world, but in their family law case as well. And it can really shape the dynamic of how a family law case goes, especially one where we have children involved, substance abuse issues might come into play. So I wanted to get somebody on who handles that type of law, kind of tell us what goes on in DUI cases. And there's no better person I could think of that could offer us that information than Joe Turner. He's been a friend of mine for over 20 years now. We've been practicing law together. We were both rookies the first day in Judge Costello's court when I met him, and we've known each other ever since. Joe, tell us a little bit about yourself.
All right. Well, I appreciate you having me on, and I look forward to this. Yes, I have been here for about 20 years practicing criminal defense. I kind of got drawn to that in no small part because that's what I got a job doing. That's where it all started with a fellow named Boot Crawford. And he seemed to know a lot about DUIs. He traveled around the country talking to other lawyers, teaching them about DUIs, and taught me a whole lot too. So I just kind of have continued on with that. And over the years, I've seen how important it is, how much a DUI can disrupt someone's life, whether they're married or not. But then in the family law context, when it involves their spouse and their children, it can be even more devastating.
Let me ask you something, Joe. As you know, you were working with Hoot and you were doing criminal defense. And, I know Hoot was very heavy in DUI and, studied that pretty hard, that body of law. Was there a case early on that just spoke to you and said, hey, this is what I'm supposed to be doing with my life?
Sure, there was a gentleman that had a commercial driver's license. Okay, so not only did he need to drive, as most of us around here do, he drove for a living. It was his livelihood. And the loss of his license and his CDL license wasn't just going to cause criminal impacts in his life, but it was going to cost him his job, his livelihood. And that's the first domino to fall, and it falls hard and fast because then wouldn't be able to pay his bills, wouldn't be able to pay his mortgage, wouldn't be able to continue supporting his family. And then before he knows it, they're looking at divorcing your end. And fortunately, we were able to find some good information that turned that case around and made it less serious for him, allowed him to keep his license. And that's when I realized that, DUIs are something that don't discriminate. Anybody can get a DUI. They just have one too many at dinner. They could be a nurse, a teacher, anybody that it can just happen.
And that's so true, Joe. Like the way you said with the dominoes falling because you lose your job, you can't pay your mortgage, you could be on the hook for child support already, having a court order to pay for that. It could affect that. It could affect so many facets of a family law case in the blink of an eye. And it happens, like you said, all the time to people who you would never think, that this person would get a DUI. It just, like you said, they had one too many, or I've even seen it. And I'm sure you could speak more to this about somebody had some prescription pills that they were supposed to be taking and they had some kind of adverse effect on them and ended up with getting pulled over and in that situation. It really is. It touches every aspect of a person's life if they find themselves in that circumstance. One of the questions I wanted to ask, and I kind of came with the list because it is such a fascinating topic, was what's something people would be surprised to learn about DUI cases versus what they see on TV?
The first one I hear so very often is, well, I wasn't even driving. The person who's asleep in their car. That's the most common case I hear about because in Florida, actual physical control is defined very broadly. The state doesn't have to prove you were driving. It has to prove you were in actual physical control of the motor vehicle, which basically means that you're either in or on the vehicle and have the ability to operate it. So that could mean, just an extreme example, sitting on the tailgate with the keys in your pocket. That can be actual physical control. And so a person sleeping in a driver's seat, especially in today's push button environment of vehicles, keys in their pocket, the state's going to prosecute those, and they do prosecute those around here.
And that's something, I think that's really critical that you just touched on. Because if I wasn't a lawyer, I wasn't your friend, I hadn't heard you tell me this 100 times already in the past, I would think I'd be a law abiding good Samaritan. I'm just going to sleep it off in the car. I'm going to sit there and just try to, sober up and not drive, not physically, drive the car and I could find myself in trouble as opposed to maybe calling a cab and getting a hotel room. So I think that is a fact that gets overlooked. And I've seen family law cases. I've actually had a friend who that happened to, who was going to sleep it off and ended up with a DUI because he was sitting in the driver's seat with the keys in his pocket. So Joe, our worlds often like collide. I've had to call you before with issues where, we've had a case where someone's either got a DUI or the other side's, been charged with a DUI, and I'm trying to find out if it's, looks like it's legitimate, or, what your take is on that case. On your end, how often do you see DUI become the first dominoes that lead to a divorce, or, the thing that blows up a custody battle?
I've seen it start with the call from the jailhouse, one spouse to the other saying, I've been arrested for DUI and I need you to bail me out. Because usually in that situation, there's been a lot that's occurred in the relationship before that. And now it's the last straw. Here you are getting arrested. You're out drinking, driving, getting arrested instead of being home with the family and taking care of us. And at least the financial issues, you're spending money on the alcohol or being out or being somewhere else. And that's just finally the thing that the other spouse can no longer take. And so that leads to the phone call to a place like yours.
Yeah.
Off and running it goes.
I tell you where I think I see it the most is when people are doing divorce, there's usually a plethora of reasons that led to the decision to get a divorce. And, substance abuse is definitely one of those that comes up. But in custody battles, because when you look at the Florida statutes, they deal with time sharing, parenting plans, and the best interest determination of the children. Substance abuse is a big issue. And if you've had a DUI, then judges start to think that's substance abuse issues because you weren't in control of your use and you used it in alcohol in a way that was irresponsible. And nothing, I think, blows up a custody case worse than DUIs with kids in the car. And I know that's a horrible thing to even think about happening, but I've had cases where that's occurred, and that plays heavy in the child custody, arena. And so I've always, if I have a case where my client has been accused of a DUI in the middle of a family law case, or I always, tell them you need to get good DUI counsel because it's going to, whether you want it to or not, or whether you believe it or not, it's going to affect the family law case. And so, that's how we see it on our end all the time. From your side of the courtroom, what are the most common ways a DUI kind of bleeds into, family law issues, custody issues, the party's finances?
Well, first off, being charged with a DUI is an expensive problem. Just the basic court costs and fines are going to start probably around about $1,000 and go up. DUI schools every bit of $450 these days, plus 12-hour classroom component and a substance abuse evaluation that costs. You could get up to 20 weeks of mandatory counseling at probably about $50 a pop. And that's before the classes, before the probation, and other fees that come along with it. Not to mention if your driver's license is suspended and you either can't get a hardship or otherwise don't qualify or don't get it done in time, having to pay transportation costs to get around. Suddenly, you can't drive yourself somewhere. You're either paying someone to drive you or taking Ubers or taxis everywhere you go. That starts piling up in a hurry.
So let me ask you this, because this is something that always, interests me. And I mean, I've always heard that if you get a DUI, like if you're lucky enough to get past the DUI and you're back on the road with your license and everything, that the insurance is allegedly astronomical. Do you know anything about that?
Sure. So, with a DUI conviction, the state of Florida is going to require a person to have for insurance for the next 3 years. Not only is it a more expensive form of insurance, it's only available in 6 or 12 month blocks. So, a lot of people pay their insurance monthly and calculate that into their monthly budget. Well, all of a sudden, to keep driving, you've got to pay either 6 months or a year of your car insurance at a time. And so often that throws people's finances out of order to where they can't afford to do that all at once. So even though they're eligible for a license, they can't afford the insurance to get it.
Yeah. And with us, one of the issues that I see where it really comes up is when you calculate child support or you're calculating alimony, we really look a lot of times at the party's kind of net income, especially with child support. And net income is kind of defined as like after taxes, after certain mandatory deductions out of your paycheck. It might be union dues or, certain mandatory things that have to come out. But I can tell you now that there's no mandatory deductions for probation, having somebody drive you to work, heightened insurance, and that can really affect a person's bottom line because they may come to me and say, "Hey, this has happened, and I got to have more money to just drive around to get to work." And there's really no relief I can get them because they're not mandatory deductions. And a lot of times, the courts will say too that there's no real change, no substantial change in circumstances because it was not an involuntary act. You voluntarily chose to drink and drive, so you can't benefit from your wrongdoing to reduce your child support. And that gets into some very tricky situations, unfortunately, because when you're looking on our end, child support can lead right back into license suspensions, can lead to contempt and potential, civil contempt jail time, writs of bodily attachment, and they get back into either, basically back at the jailhouse and a civil kind of quasi criminal situation on the child support. And that causes big, big problems in the family law case. And it's just a direct result, unfortunately, of that one night, that one mistake, that one lapse in judgment. Joe, if someone was going through a divorce and they pick up a DUI, what do you wish they really understood immediately?
First thing is, and it starts at jail, don't talk about the charge. I can't tell you how many cases I've had where spouse picks up the phone, other spouse is angry, and they're telling, "Why'd you do this?" And the person in the jailhouse confesses their whole case. I only had 7 drinks before I left the bar. It had been an hour since I'd been drinking. Whatever else they're trying to say to minimize it to their spouse is just handing the prosecutor evidence against them. All those phone calls are recorded and they're going straight to the people that are prosecuting them. So, step one is, even from the jailhouse, don't talk about the case. Once they get out, it's important that that advice continues. Don't go post about it on your social media. Don't talk to somebody about it that's going to want to use it against you. Okay. So, the best advice is to only speak to it with your attorneys where that information is confidential.
I'll tell you this, I'll go one step further, right? Joe's worried about them bugging the jail phones, and rightfully so, because I've heard a little secret is I used to do some criminal law. It wasn't my forte like Joe's, but I've heard those tapes before where they record the phone calls. But I'll go one step further in family law cases. If, your spouse, who may be soon to be your ex, or maybe you call your children's mother because that's the only phone number you got memorized, and she or he are looking for some reason to settle the score or to reopen the custody case or what have you. I've seen, those calls and that information be used as leverage in the family law case. I have seen cases where the family law case and there's a criminal case, and they're both going on at the same time, and the ex-spouse becomes the chief witness for the prosecutor because they, she or he have no love lost for the defendant, and they volunteer their information up. So you don't want to put yourself in a position where your ex chooses to take the stand and tells the prosecutor, yeah, he confessed, because that may, help the prosecutor in the criminal case, and the ex may thinking that the conviction is going to help in the family law case. So you really want to watch out for that, because that goes both ways. It's not just the prosecutor. Sometimes in these family law matters, people sometimes do pretty aggressive or pretty petty maneuvering, and they're looking out for what's, in their advantage. So you want to be careful. Wholeheartedly agree with Joe. Basically, keep your mouth shut, don't say anything. Um, and I think that the phone thing is really really critical, because I think a lot of people realize not to say something to the police because it can be used against you. Hopefully, the police actually tell you that, and give you your Miranda warnings.
Well,
But
that's another point that's often confused, is people believe they were supposed to be given Miranda warnings when they're not, because they see it on TV right at the handcuffs all the time.
right.
That's not necessarily when they have to tell you about it. And statements that you give voluntarily without being questioned may not be subject to the protections of Miranda. So,
So what you're saying, Joe, is, I think, and correct me if I'm wrong, because you're the criminal defense attorney. They cuff me, they put me in the back of the car. They're not interrogating me. They're not asking me any questions, so they don't have to necessarily Mirandize me. And I say, oh, darn, I shouldn't have drank those 15 beers at the party. And the cop hears it, or the videotape in the car captures it. that might be free game and not protected by Miranda, right?
That's correct.
And for those listening, Joe, what is Miranda? We know what Miranda is. We're talking about it, but they may not know out there what Miranda is.
Sure, it's that they have the right to remain silent, that they have the right to counsel if they can't afford counsel. Counsel may be provided to them at no cost. They have the right to stop being questioned at any time, even if they consent and waive it. They don't have to continue answering their questions if all of a sudden they realize, I am the subject of this investigation, not a witness. But basically, anytime a person hears an officer read them Miranda, that should be a bright flag to be quiet. That is not there for your protection. It's there so they can use it against you.
And you, at that point, you have the right to obviously remain silent. And you also have perhaps the right to request your attorney be present or to that you don't want to talk without your attorney, or you can request an attorney too, can't you, at that time?
Yes. Now, where this gets a little complicated in the DUI world is that a person is not entitled to speak to an attorney before they make the decision to submit to either a breathalyzer, a urinalysis, or a blood test. The law has carved that out. So I will see a lot of people on their videos or on the police body cam. Well, I want to talk to a lawyer before I do this. I want to talk to a lawyer. I'm entitled to a lawyer. And unfortunately, at that point, they are not. And so people often get confused by that.
That's good to know. That was something that I learned here on the podcast. I won't comment on why that might be, why they don't want you to have the lawyer present. But let me give you a scenario here, and I'll kind of set it up, and then you can kind of walk us through the process because DUI is a very interesting, intricate process. I think you were hitting on that from the stop, the field sobrieties, the blood or breath test. It's a full blown process. I remember, sometimes coming by the office and hearing you and Hoot walk through all the minuscule details of the process. But here's the setup, Joe. You got a married parent with 2 kids, no criminal history, gets a DUI after work happy hour. All right. Walk us through what happens in the first 72 hours after that arrest.
All right. So spouse is presumably headed home, gets pulled over, maybe for speeding, maybe for weaving, maybe not stopping all the way at a stop sign. Those are very common. Everybody check your tag lights. They like to pull you over for that. But anyway, they get stopped. The officer comes up to the window. The first thing the officer's looking for is to just make initial contact and get you talking. They want to hear what you're saying. They're going to ask you things. Where have you been? What are you doing today? They want to hear how you sound, hear how you react to those questions. That's where they're initially determining, do I think this person may be impaired? They're looking for bloodshot and watery eyes. They're listening for slurred words. When they ask for your license and registration, are you fumbling through your wallet? Do you hand them your city card instead of your license? When you pull into the glove box, do you give them 3 years ago's registration or do you hand them the correct one? They're looking at all these little things before most drivers have even realized that a DUI investigation has begun. They're smelling for the odor of an alcoholic beverage. At that point, then they'll go do their warrant checks and whatever and come back and say, well, I think you might be under the influence of an alcoholic beverage tonight. You told me you were coming from the work happy hour. So, why don't you get out of the car and see? Let me see if you're okay to drive away from here. That's one of their favorite lines. Let me see if you're okay to drive away from here. That's how the officer is convincing you to participate in the voluntary field sobriety exercises. There is no penalty for not doing the HGN, follow my finger or follow my pen, standing on one leg, doing the heel to toe exercise. There's no penalty for those. Now, in most instances, the officer is probably going to place you under arrest based on what they've already seen when you refuse those. But that prevents you from being on the officer's body cam looking a little silly, not following their instructions. It's essentially a game of Simon Says, except you go to jail at the end. So I do not recommend that a person does those, and there's no penalty for that. After they place you under arrest, you'll be asked whether you want to submit to a breathalyzer or a urinalysis, depending on what they believe you're under the influence of. Most of the time it's alcohol. So they'll ask for a breath test. If they think it's marijuana or prescription pills and have probable cause for that, they may ask for a urine test. But that request won't happen until you're under arrest. And another thing most people don't understand is I have people that blow under the limit, but they don't get to go home because you're already under arrest. So whether you blow into the machine or not, it's not changing whether you go to jail that night. In addition, back in October of 2025, a new law went into effect in the state of Florida that made the first time a person refuses a breath test a misdemeanor. It used to be not until the second refusal became a crime. The first was just administrative. But now the first time is a crime, a second-degree misdemeanor, up to 60 days in jail, simply for being under arrest and not complying with the officer's request to take the test. So that's all probably in the first 2 hours.
Wow.
Yeah. So then the
That's a lot
person
of real estate, man. A lot of real estate in 2 hours. Your
lot of
life is
things
you went
I
from
can't tell
happy
you.
hour to not so happy in about 2 hours.
Unhappy hour in a hurry.
Yeah.
And I mean, I can't tell you, I've seen countless body cams where the entire DUI investigation is 10 to 12 minutes long, from the time the officer believes he smells the odor of an alcoholic beverage to the person refusing to do field sobrieties to in handcuffs in the car we go. Will you take the test? Yes or no? A lot of people say no. That'll bring up some administrative penalties. I suggest we get to those a little bit later because not all of that's happening in the first 72 hours. And then you get to the jailhouse. The jail's going to do, a brief workover, make sure you're healthy enough to go to jail. And they'll have you submit to a breath test for the jail's purposes for whether they put you in the drunk tank or whether they put you in general population. That breath test is not recorded. Every now and then we get a peek at it on the officer's body cam, but it is not used for evidentiary purposes. It's used for the booking purposes of the jail. A person charged with DUI has to remain in jail for a minimum of 8 hours or when they're below 0.08. That's another reason the jail tests you. Well, we do have a bond schedule in the state of Florida now. So most DUIs without injury or property damage are going to be bonded out prior to first appearance, but the others will go to first appearance, have a bond set by a judge, either pretrial release where they phone in once a week or a monetary bond that they post with a bondsman or pay a cash bond. Then you get out. Now is when we get to those administrative things the next day when you're out of jail. In Florida, you only have 10 days to get a hearing requested with the DMV because the first thing that's happening in a DUI is that the DMV is administratively trying to suspend your driver's license. That's wholly separate from the courthouse. Okay, so if you don't request that within 10 days, then depending on whether you submitted to the breath, urine, or blood test, whether you refused it, action will start happening on your license. If you request the hearing in that first 10 days, then we get an opportunity to have a temporary driving permit that's good for about 6 weeks to allow us to have a hearing at the DMV to determine if it's proper for them to suspend your license. Those are, over the years, they've really chipped away at those. They're almost rubber stamp procedures anymore. The officer has to make a pretty grand mistake to stand a good chance of winning the administrative hearing anymore. But sometimes they do, so it's worth the look. In response to that, the state has, if it's a first-time DUI, you can waive the right to that hearing and go straight to a business purposes license. So then you can have a work permit is what most people call it. You can have a work permit for the 6 to 12 months of the suspension without risking time lost from the DMV.
Let me ask you this about the process. A couple of questions kind of just jumped to mind, and they may be silly, but have you ever seen in all your years somebody refuse to? I mean, like the police officer comes to the door, they just hand them the driver's license registration, and they refuse to small talk. Have you ever seen anything like that? Like, am I obligated to make small talk with you?
You are not. And I advise people to speak as little as possible. Because one, if there is the odor of an alcoholic beverage, the more you open your mouth, the more it's coming out. And they're looking for those slurred words. So no, you're not required to answer where are you coming from or where are you going. I've watched around on the internet and I see some of these that suggest, I don't wish to tell you about my day, or these kind of quasi-combative statements, putting forth your rights, if you will. I don't believe those are a good strategy either. You can be polite and not give them anything at the same time. But once you start showing the officer that you know your rights or telling them how they're doing their job wrong, things are going to get a lot more difficult for you just from a practical standpoint. So you can hand them the information. Where are you going? No, thank you. Here's my stuff. Brief sentences without giving them too much. But no, you're not required to answer their questions at that point. You are required to
Here,
provide identification and registration.
the
And
next thing that you said that kind of, piqued my interest was you said sometimes you saw the second breath test on the body cam. Have you ever seen a big disparity between the first machine and the second machine?
so far, the only instances I've had where I have been fortunate enough to have that, the person had refused, and the number that we caught was actually beneficial to the defense of their case. So while it wasn't admissible in evidence at trial, we would never get that in at trial because that machine isn't necessarily kept to the same standards as a machine used for evidentiary purposes. But that gives me great leverage with the prosecutor to say, hey, we just saw this person blow an 04, for example. even though they refused the other one. Let's work this out to something favorable.
Let me ask this one too. Why you went through that, because it's just fascinating. So I get out the car, I do the field sobrieties. I don't do a good job at the high stakes. Simon Says I get put in the back of the car. I get driven to the police station or jail or wherever the machine's at, and I blow under the limit. Am I getting unarrested? Are they letting me go? What happens then?
There is no process to unarrest you. I would say what happens a fair amount of the time is then that the officer will think, well, I can't possibly be wrong. You must be on something. So they'll follow that up with a request for a urine test. It must.
Do I have to give them the urine test? Is that a refusal too if I don't?
So here's the thing with the urine test. The refusal to it does trigger administrative action. Taking a urine test and a positive result does not trigger administrative action. So for the DMV purposes, there's no penalty for taking the urine test and there being something in it. On the criminal court side, if there's going to be something in your urine, it will sort of depend on what it is. Let's say, for example, they find marijuana. Well, if as the criminal case unfolds, we didn't find any recent use of marijuana in the car, a roach in the ashtray, or it didn't smell like recently smoked marijuana or vaped marijuana, there's no way to tell whether that's use from 10, 20, 30 days ago or use right here, right now, without the assistance of a drug recognition expert, which a few of the officers around here are. But by that point in time, they probably haven't done the type of investigation necessary. So in most instances, I would lean towards just take the urine test. They also, for evidentiary purposes, the officer needs to have developed separate probable cause to request it. So they can't just request it because you blew under. They need to have seen a pill bottle or drugs or something else that may be present in urine that's not in breath. And so oftentimes there are maneuvers to keep that out of evidence anyway.
All right, so this may be going down the rabbit hole, but it's just so interesting. So I know, like, the police come to my door. They ask, "Can I come in?" I let them in. They don't have to have a warrant because I let them in. If I'm down there and I've been arrested and I've blown and it came out positive for me that I'm not drunk according to I don't have the blood alcohol level required by the state of Florida for driving, under the influence. And they say, "Hey, will you take a urine test?" Versus you're taking a urine test. Does that make a difference if they ask me and I say yes, did I voluntarily waive my rights? Because they asked and I just said, "Yeah, sure."
They're most likely going to read you implied consent again. The officer would have or should have read you implied consent prior to the breath test. They'll most likely read you implied consent again. And then that's the decision to either take it or not take it. You can withdraw that consent, which is what leads to the administrative action where your license gets suspended. Because when a person signs up for their license, they agree to take any lawfully requested test. And so it's actually your license gets suspended when you withdraw the consent that you had given to the state when you initially got your license.
Yes, and like I said, I don't want to get lost in the details too much, but if there's no pill bottle, there's no roach in the ashtray, I might think it's not a lawful request. You know what I mean? Or that's what I'm trying to
Right.
get at.
Yeah,
Who's the
that's not the time
arbiter
to
of
make
that at
that
the
argument.
jailhouse?
Yeah, that's not the time to make that argument, though. You're
Okay,
going to lose that argument with the officer. In that
so
instance,
you don't waive the ability for your criminal defense attorney to raise that argument by peeing and giving the urine test.
correct. Yeah, no, by giving it, you're in a better position to make the argument.
Okay, that's what I was asking. All
Gotcha.
right, so you kind of walked us through that. So on your first offense, and let's say it doesn't go well for you, it's your first offense, and you look at everything, and it's not going to be a great case to take to trial. What are the immediate consequences they're facing on the criminal side?
So, a first time DUI, Florida law has some minimums that are required by law. The bare bones version of it's going to be about 12 months of county probation, $1,000 court costs and fines, a $50 cost of prosecution, another 50 hours of community service, and then DUI school, which you will have had to do to reinstate your license. So, you don't do it twice, but you will take it somewhere in the process. What they call the Victim Impact Panel. This is about a 2 hour class that's attended online. Then there can be 6 to 12 months of license suspension from the courthouse. That's completely separate from any DMV suspension. And while they can run at the same time, depending on how long your criminal case takes to be concluded, you may have your license back from the DMV's administrative suspension and can get a second suspension from the courthouse. That also confuses people often. There'd be 10 days of vehicle immobilization. So we kind of call it car jail. The vehicle has to get locked down for 10 days. If that person charged with DUI was the owner of it. If it's a different owner, it's a single family vehicle, there are some exceptions to clear that up. And typically don't possess or consume alcohol while you're on probation, and random urinalysis and breath tests that, if you fail, can lead to violations of probation.
I'm going to tell you, like on our end, let's say you're going through a custody case and, there's a DUI that pops up. I will tell you, we start off with, we go to the clerk site, we get the records, we get the probable cause, affidavits, police reports, tickets, anything in the file. We find the agency. If it's the sheriff's office or highway patrol, we're going to do a public records request. We're going to want the footage, the videos, the body cams, the whole thing. We try to get all that evidence off the bat. And if it appears that the person has got a history of drinking, it's not a one off thing, then that may be enough to still bring it up in the custody case. If the kids are involved, there's a definite nexus between the behavior and the children. That's going to make it concrete that we got a problem. We're going to probably be raising, various motions. A lot of people are still really not aware of this, that Florida is now for child custody, the presumption's equal time sharing, 50-50. The judge is supposed to still weigh all of the factors in 6113, all the best interest factors for the kids that are spelled out. But I will tell you, I think while there is no super factor according to the law or to the statute, substance abuse and domestic violence seem to be the ones that really move it off the 50-50 presumption the fastest. In those cases, you're going to see the body cam footage. You're probably going to have DUI trial number two. And a lot of times, what happens in the family law case, if someone like Joe is representing you and the criminal case is not over, but we get to family law court first, I normally, if you're my client and you've had the DUI allegation made against you, I'm going to tell you, you need to really talk to your criminal defense attorney, because if we go to court and you're asked questions about the DUI or you make statements about the DUI in court, those can be used against you and you could be waiving your Fifth Amendment right. So sometimes why this custody thing is unfolding and you want to tell your side of the story, and maybe it was a bad stop, or maybe, something else was going on and you're diabetic and that's why the machine was off, or there's all kinds of things, reasonable explanations that can explain what's going on. You may have to literally sit there quiet, not talking, because you don't want to mess up your criminal case, and then really, have a conviction, or have that, conviction used against you potentially at the final hearing. So, it's a world of entanglement. Um, the two issues become entangled. And I always tell my clients, like, depending on what you're charged with, if there's a criminal case, then criminal case may have to take precedent over the family law case, and you may have to just invoke your right to stay silent unless you and your defense attorney decide that that's not an important for your case or your defense. But I've yet to meet a criminal defense attorney who said, "No, please go to court and talk about it." It's normally, like you said off the bat, be quiet, keep your mouth shut, don't say anything. And so we're sitting there, with arrows being shot at us, and all we can do, man, at that point is cross-examine and duck and dodge, because we can't go on the offensive, and the judge can't really even hear your story without risk of, you getting trapped maybe in a bad question on cross-examination and that being used against you in the criminal case. So, um, those are real life consequences just off the first offense. And it's a different perspective from our side of the aisle, because why a DUI is bad, it's a misdemeanor. There's, a way out over time. There's a process, probation, counseling, the things that they're going to make you do. And, what would you say, Joe? You could maybe be done with that in about a year, 6 months. How long are the consequences?
Yeah, most probations are structured at 12 months. If you've completed all the conditions at 6 and it's a first time DUI, most judges, if asked, will release a person early from their probation. But 6 months at a minimum, you're going to be dealing with it. And that's after the 6 to 8 or so months of going through the court process to get to that point.
So
And if I
go
can add on to you've mentioned a couple times a DUI with children in the car. A very common situation I see with that is that the police officer may charge child neglect on that, which is a felony. So now the DUI is not, even though the DUI is essentially the basis of it, that's not the person's largest problem, because what will come along with that will be a criminal no contact order with the children that are in the car. And I'm sure that causes all kinds of chaos on your side of the line.
Yeah, it really does. And what I was, trying to drive the point home here is you might be done with your DUI case in 6 months or a year, and maybe you got that behind you, you got your probation, you got everything done. Well, if we have lost custody at a final hearing, there's no way for me to go back to court and modify and say probation's up. I have to wait for a new substantial change in circumstances, which may or may not ever come. So that can really affect you for a long time with your relationship with your kids. I mean, most people, hey, I got to call you every Monday. I got to check in. I got to go to probation once a month. I got to pay this. Like those are hassles. And nobody wants to do it, and it's part of the process and the punishment of, the DUI, but you don't get time back with your kids and you don't get a redo, and it could have long-term effects on custody, and then maybe you're waiting years for hopefully something to substantially change so you can get back in the game and say, "Judge, I got my life together. I got this," and in Florida, it does have some cases that are out there. They're debatable, maybe if they're still in effect. Um, because we got the new statute back in 2023. But there were some pretty strong cases that said getting your act together is not a substantial change in circumstances. Because you dried up and quit drinking and did everything, got back on the straight and narrow, that may not be enough to change the schedule. So that's one. The other thing you talked about is the no contact orders. Those cause a world of confusion and problems because if you have a criminal no contact order, that's where the judge is telling the defendant in the case to stay away from the victims. In this case, like Joe's scenario, if it's neglect of a child, stay away from your children. You're court ordered to not be around, and they inevitably somehow in the process think that's something to do with me on the custody end or on the divorce case. And I tell them that one circuit judge, in my opinion, doesn't have the authority to overturn another circuit judge. And I'm not about to risk that, the family law judge said it's okay, but the criminal judge said no. And then maybe the criminal judge signs a warrant for you for violating your terms of your release. So there's a lot of criminal defense attorney conversations I have to have. And literally, I'm having to repeat this over and over because I even think criminal defense attorneys sometimes think the family law case will just control it. I have to get the defense attorney to go in and hopefully get the criminal judge to either say, "Yeah, I'm going to lift it," or this order will, be in effect until a subsequent order by the family law court in case number such and such. And then that way I know, hey, I get an order from a family law judge. The criminal judge has already said he's going to acquiesce to the family law judge if the family law judge wants you around and what the time sharing will be. Sometimes that's, getting your criminal lawyer to listen to your family lawyer and getting two lawyers on the same page to convince a judge to do something is sounds like it would be straightforward and it is often not, and people get very upset and think it's on our end of the line. It's not. It's on it's on the criminal side if there's that no contact order. And lots of times, if there's a criminal case and I'm representing you in the family law case, I try to slow walk the case a little bit if I can. The other side's trying to get the court to point out, here's the body cam, here's this, here's, I'm trying to slow walk it and duck and dodge and as much as I possibly can, hoping that the criminal defense attorney finds, oh, there was no probable cause here. Or, oh, they messed up this, or oh, the this machine wasn't calibrated correctly, or any number of defenses out there. Because if it goes away, then I'm going to be and then I'm going to be one putting my pedal down to the metal, saying, "But hey, judge, um, they were acquitted, or case was dropped, or what have you." But another thing people tend to really get confused is the varying burdens of proof. So in a criminal case, Joe, the burden of proof is what?
Beyond and the exclusion of every reasonable doubt.
Okay, in a family law case, it's just the preponderance. How I always try to explain this and how I remember it is I had a law school professor and he wrote a bar graph on the whiteboard, and he had, beyond a reasonable doubt, and he wrote 99.9. Then he had clear and convincing, and he had 75%. Then he had preponderance, and he had 51%. So another scenario that can happen in these cases is you get acquitted on the DUI. you don't get found to have driven under the influence. Well, in the criminal or in the family law case, it's not my job to prove that, you committed a DUI or you were innocent of a DUI. I'm just trying to show that the kids are safe with you and it'd be in their best interest to have a good relationship with you. The judge can still say, I don't think, I don't know what happened in the criminal case. Maybe it wasn't a DUI. Maybe, maybe there was a technicality with the machine or this, this happened or that happened. But I see dad slurring, falling over. The kids are there, you know, it's still not safe. And there's been 51% enough evidence in my mind that he'd been drinking and that had an adverse effect on the kids. And there you go. Like it's still evidence being used against you. And that's one of the real trick issues of I think people, sometimes I'm going to tell my age a little bit, but when I was in high school, I was glued to the OJ Simpson trial
Certainly.
and there was a not guilty. And then about a year or two later, there was a civil judgment for millions and millions of dollars. I was like, how could you be not guilty and then you get over here found to be liable for millions of dollars? And that's that same principle, different burdens of proof. One's beyond a reasonable doubt, 1%. So the jury over here said you didn't have 99.9, but the jury over here said we had 51. So there's various burdens of proof, and that's something that people really struggle with when they find themselves caught up in these two worlds of
I've been
family
studying it
law.
25 years and it's still struggles.
Yeah, it doesn't make sense,
It,
but
just because you're found not guilty doesn't make it invisible, doesn't make it
yeah,
go away.
yeah. And judges, when a judge hears a family law case with children, do they care, that about you and do they care about the other parent? Sure. But their first priority is going to be the kid because that's their number one priority is make sure that this time sharing schedule is in the kid's best interest. And if they think the alcohol is an issue or your judgment's an issue, that's going to affect it. And they're going to put the kid's safety above your right as a parent to have those weekends or holidays or whatever it is you're shooting for as far as time sharing goes. It's going to definitely play a, Joe, I mean, if you feel comfortable answering this, I know DUI, you deal with a lot of allegations of alcohol. And, sometimes they're true and sometimes they're untrue. But as a DUI attorney, have you kind of come up with a kind of a way like where you sense this isn't just a one off, this is a bigger problem? And if you do, if you sense that, like what advice do you kind of give a client who you think is it's not a one off? I made a mistake. I left happy hour, should have sat there for a couple hours versus a repeat problem. Have you kind of picked up on that? And what do you tell these people?
So with those people, certainly I'm running a criminal defense firm, not a rehab center,
Right.
but I do have a list of resources that I like to make available to them for them to peruse because I do have people sometimes come to me and they just flat out tell me, I need help. This has gotten out of hand. And
Yeah.
for whatever reason, I'm the first person they could tell. And so I certainly want to help those people get the type of help they have. As far as identifying it, I just kind of rely on my eyes. I've been doing it for a little over 20 years now. And most of the time I can pick them out. We're not always right, but no one is. But, I want those people that want treatment. I certainly want to point them in the right direction. And, they need to be making a concerted effort. This isn't, I'm going to, go to 2 AA classes a week for a month. That's not going to get the job done. They need a continuity of purpose. They need to get one done every day for the next 90 or 120 days. Some people need inpatient treatment. They need to just be separated from it for a while. And in some ways separated from the stresses of life that were driving them to that, to get the tools necessary to come back and live without the substance. So, yeah, go ahead.
I'll tell you the same, it's kind of the same thing here. Sometimes people come in here and they spill their soul and they feel safe because it's got, attorney client privilege. And I try to direct people all the time, to counseling, to rehab if they have issues like that going on. Because while I'm your lawyer, I'm running a family law practice, and that's my job is to defend you or represent you or bring your case to the court's attention. I'm also a person, and I'd like to think that our clients are our friends in a professional manner, but I want to look out for them. In my experience as a family law attorney, let's just say you got convicted of the DUI and it was bad, and we have a little bit of runway before we go to court, and I can get some time. Maybe the docket's busy. I want to tell you, do the rehab. I'm going to tell you to go to AA every day. If I think it's a drug problem, I've told many people you owe me a urine test every week. Or when I call you at random, you're going to bring me one. And the reason why is because one, you need the help. If you told me you needed the help, even if you didn't tell me you needed the help, when we go to court, nothing would make me happier than, here's a certificate where I completed this rehab. Here's where I've taken it serious and I've kept a log or a calendar of every time I went to AA. If your sponsor or somebody like that in that role is willing to come to court and say, hey, yeah, man, Gerard's been there every day for 90 days or 100 days and is really taking the process serious, it can really make a big difference in how the court looks at that event because we all make mistakes.
That's right.
It's how we handle them. And if you've handled it with grace and maturity and really fallen on the sword and taken the steps that were necessary, I've had one judge tell me in a ruling or a pronouncement, so there's nothing I can do to you because you've already done it to yourself. You've already completed everything I would ask you to do. I know criminal law is a little more stiff than family law because you're dealing with prosecutors and statistics and convictions and the law in a lot of ways has become a very vicious statistics machine. Do you find that if you had somebody who really knew that they messed up and it was clear and the prosecutor knew they had the cards and you knew they had the cards and you went down and said, look, the person has completed a year of Alcoholics Anonymous, went to rehab, done these things, that there might be some leniency where the law allows them to be lenient?
Absolutely. I find that I tell my clients that recommend to do this too. I'm like, it's our way of bringing some good faith to the table.
Yeah.
Yeah, you mentioned the runway of the case. Well, when they first get charged, I do have a pretty good runway till I know what would be the natural end of that case usually. And my clients have the time to go do those things. And when I present that to the prosecutor, it gives them something to put in their file and a reason to make my person a person and not just a statistic and make them give the prosecutor a reason to do something different than they normally do. So not only is it helpful to the person, because ultimately, if we treat the root cause of it, I don't anticipate my client's going to see me again, if we really get to the bottom of it. And I try and make that argument to the prosecutors through their hard work, my client's hard work.
Sometimes I think this gets lost, and it's not in every case. And it's something that you definitely need to look at the specific case, consult with your lawyer, look at everything. Everything we're saying here today is just for educational purposes. But sometimes I find in family law court, if you are the underdog and you fall on your sword and you admit that, hey, man, I messed this up, but these are all the things I've done. I've seen judges kind of fall in love with the underdog sometimes, and it's a lot better than even I anticipated it was going to be based on my client's hard work, dedication, and commitment to getting their life back on track. And if you can do that, like some people hesitate and say, well, I'm going to see how this goes, or I'm going to, see how this motion goes. And I tell them, family law, the runway with us is getting very short these days. There's a lot of pressure on moving the cases extremely fast. And I'm not saying that's a bad thing or good thing. It's not my place to comment on the judicial system. But, like I said, if I can get all that stuff done before the final hearing, I can bring it up. If it's stuff that happened after the final hearing and you went to rehab, it may not be enough of a substantial change to get back in the game. It may be, hey, judgment's in, it's over, and you got to wait for a substantial change to occur. But Joe, just like I promised you once we were talking, about doing the podcast, the hour would fly by, and it has.
You're
So
correct.
Joe, if people have more questions about, DUIs, DUI law, criminal defense, where can they find you? What's your website and how they get in contact with you?
Sure. I'm the Turner Law Office. My website address is the DUI Joe, THEDUIJOE.com. And my phone number is 850-913-9661. I get a text message of any voicemail that's left, and we answer them pretty close to 24/7. I can't always do something for you at 2 in the morning, but I'll know you need help and we'll get to it as quick as I can find a judge.
Well, Joe, I appreciate you coming on, and we are certainly going to have you on again because we talked about DUIs, but Joe does a whole variety of criminal defense work, and he's a good plethora of information. He's someone I call. In fact, I had a friend who reached out to me a few weeks ago with a driver's license issue, and Joe is my go-to on the driver's license issues of any type. And so we'll definitely have him on because I know those are other things that come up all the time in custody cases, driving with suspended license.
We can do a whole hour on driver's licenses.
Yeah, I could use the education because it is a you would think it would be simple. It is very complicated. But Joe, we thank you so much for coming on, and we will see you guys next time. Thank you for tuning in and listening. And if you can, will you please like, subscribe, share? We do the podcast. We don't do any advertising on it or anything like that. It's just for good informational purposes. And, we want to get the information to the people going through family law cases or family law and maybe criminal cases simultaneously so they have the best information possible. And, without your help, we can't do that. So thanks everybody for tuning in, and we'll see you guys soon.